Hi, everybody, and good afternoon. I'm Deborah Oppenheimer, if you've never met me, and I am one of the partners here at Altitude Community Law. On your screen, you should see the PowerPoint presentation in the center of it. That should take up most of the screen. There should be a small box in the bottom right-hand side with a video feed with me in the corner. On your left side, you should see a menu, tells you how many people are in it, and you should see a box that's got a question mark in it. If you click on that, that's where you can type in questions and answers, and you can add them in, and I will try and get to them, some as we're going along and some at the end, depending on how things go. CMCA credits are automatically generated based upon the webinar hosting site, and they will provide us an attendance confirmation report. Once we get that report, then we will send you guys the credits via email. It should be about 48 hours following the webinar. The credits aren't transferable. If you have any questions about your CMCA credits, please email Summer Sims, which is SSIMS@altitude.law, or call 303-991-2076 if you have any questions about the CMCA credits. So let's get started. So obviously, if you've ever attended any of our seminars, you know that, in fact, there's all kinds of other resources on our website, and you can also sign up for our blog and our newsletter. This is all that contact information, so that if you need to get more information, you can. So what kind of summer issues are we talking about? What does community association have to deal with? It's almost all the P's. It's the pools, it's the playgrounds, it's your pets are out and about, there's parties in the park, there's parties in people's homes, and it's also construction season. So we're going to try and talk about some of the things, managers, that hit you every summer, and the main issues that you have to try and fight your way through. So first things first, when we're talking about the pool, we have to worry about FHA issues when we're talking about pool rules. We have to worry about just the risk of harm to kids and anybody. Is the HOA going to have a lifeguard? Are they not going to have a lifeguard? What are the risks either way? What are the costs about these issues? And then what are enforcement issues? So first things first, what's wrong with limiting kids, pools, pets? What kind of things do we have to run into, and what do we have to worry about? Well, we have to worry about FHA, and we have to worry about the Civil Rights Act. That's Fair Housing Act, American with Disabilities Act. Each of those plays a different rule when we're talking about the pool. So let's start with the FHA. FHA means that you cannot have kid-specific rules. Why? Because if you prohibit kids in your rules around a pool, you could be discriminating against families, and that's how the FHA comes into play. It's illegal for a community to say, I don't want to have kids around, I don't want to deal with kids. That is familial discrimination, and the Fair Housing Act prohibits it. So when you have a rule that says no kids without an adult, that runs afoul of the FHA. Now, are there any exceptions to the FHA rule? Yes, there is. If in fact your rule is something that you can tie strictly to safety, right, then in fact you can allow it. That's an exception to the rule. So where does that line drawn? Well, we look to case law when we start talking about what really truly is a safety inspired rule. And so you frequently see no children under the age of 12 or no children under the age of 13. That line's not really clear. There's no absolute. So we're just, again, trying to focus on safety. But what you're trying to say is no children under the age of 12 may be unattended at the pool. Why? Because kids are kids, and kids are going to run around unless there's an adult telling them don't run at the pool, don't do things that are unsafe at the pool. And obviously, if they fall in the pool, they could, even if they're good swimmers, if they fall in the pool, they could hit their head. There could be injuries. And so there can be rules that say no kids under the age of 12 without an adult, because again, that's something you want to make sure that we're doing. We're talking safety. One of the things that you want to have is rules that, in fact, you have that apply to everybody, which is no running at the pool, right? Don't have children shouldn't run at the pool. Just have no running at the pool. Okay. There's no reason to limit it to children. We don't want anybody running at the pool because the deck could be slick and they could fall and hurt themselves. So when you have rules, there are ways to have those rules that still pertain to safety, but don't focus on kids. They focus on the activity that's unsafe. What about lap time or adult only swim time? You cannot have an adult only swim time. There's just no way you can do it. You can have, the hours of 7 to 8 are for lap swimming only. And that allows it so that the adults can come in and do laps for exercise. And if children, maybe you have teenagers who are on a swim team, they might want to do laps too. Anybody can come in and do lap time, but your rule cannot be adult only time. Can't have it. The only time that you can do things like that is if you are in a HOPA community, which is Housing for Older Persons Act. And that means that community is designated to a certain age group, and there are all rules in your declaration that create that community under the HOPA guidelines. Those communities can have no kids. Those communities can have rules specifically not allowing children in certain areas because it is a housing for older persons. And so that's the only kind of community that can have kid-specific rules. What about diaper rules or clothing rules? You want to be really careful with your clothing rules, okay? Why are clothing rules an issue? Clothing rules are an issue because oftentimes there are religious concerns about what is worn. Now, there is no requirement that you give accommodations to religion, but you cannot discriminate against it. So you don't want to have a rule that talks about or only talks about the clothing. You want to talk about things that focus on why you care about clothing. The same thing about diapers. Diapers is going to be a focus on kids. We don't want to go there. We want to have rules that, again, deal with the problem, which is you don't want a health hazard in your pool because of somebody who it has continence issues. Okay, so let's look at it. 16 and under must be accompanied by an adult, probably discriminatory on its face, right? All users must be proficient swimmers, fine. Children under the age of 5 may not use the pool, clearly discriminatory on its face. It's just like an adult swim. Now, could you modify it? Yeah, you could say children under the age of 12 must be accompanied by an adult because we really look at kids under the age of 12, they're not thinking, even at the proficient swimmers, they're not thinking clearly when they're with their friends playing in the pool. And the pool itself is a hazardous area. The deck's slick and they could fall and hit their head. And then even if they're proficient, they're going to be problems. So again, work through your rules, make sure what your rules really point to is a safety concern. Children under the age of 5 accompanying with an adult may be in the pool. That's fine. Again, really want to work with your focus is safety issues because that's how you're going to get these rules that are not going to be considered discriminatory. Children must be potty trained. Again, you're focusing on children. The alternative is all swimmers, right? Must have control of their bowels or wear appropriate swimwear so that there is no health hazards, right? Because senior citizens sometimes have those same issues, right? Children shall not be permitted to play in the pool. Why limit it to children, right? Again, no playing or loitering in the pool area, no running in the pool area. Make it so that it's much broader, make it so it addresses everybody, make it so that you're looking at it from a perspective that you're not focusing it as kids, right? So no running in the pool area because we don't want anybody running. Anybody can slip, whether you're an adult, whether you're a teenager, whether you're a kid. Nobody should be running in the pool. That's just something we want to be consistent on. Again, the swimwear needs to focus on, we don't want frayed materials, right? because that's the real concern. We don't care what somebody jumps in the pool and wears. We care what happens to our filters. We care what happens to our drains. We care that their clothing can't get caught in a drain such that they could be in danger themselves, right? So the swimwear has to have no loose threads, no fraying materials. We want to focus on the issue that we have a rational purpose in. Remember, any rule that an HOA ever adopts has to support and further the goals of the community, right? And when we're talking about pools, what is the goal of the community? The goal is not to overuse it, not to cause additional costs to us, and not to have anybody harmed at the pool. Those are our concerns for that common area. And so when we have a concern and we can attach the rule to really further the purpose of it and get away from picking on particular groups, right? That's the main thing that you want to focus on. Again, when you get those requests and somebody wants to wear something particular and you're concerned, focus in on the concern. The concern is the filters. Their concern is their religion. Now, you don't have a duty to just allow them to wear whatever they wish to wear, because you don't have to accommodate religion. You just can't discriminate against it. And so the main thing that you want to do is really work with, when there's a request, have that discussion, really explain your concerns. Maybe bring your pool guy in and say, look, here's what damages a filter if, threads get caught in it. Here's what damages, and here's what, can be a risk to a swimmer if they have loose things that could get sucked into some of the different areas. These are things that affect everybody. And if you have that discussion, they can come at it with their concerns. They want to make sure that their children, their family can wear what meets the requirements of their religion. That's their concern. And your concern is you don't want them at risk by their clothing, and you don't want your pool at risk by the clothing. And if you work together and have that interactive dialogue, one, you're going to meet all the requirements of FHA, because FHA keys in on having that dialogue, making the discussion of how do we get to a place that works for both of us. And that's very key for any kind of FHA thing. Remember, this also comes up in the summertime. Your clubhouse is going to be used more, right? Can you have rules about religious activities in the clubhouse? Probably not. You're probably not going to be able to have a rule that says you can't use the clubhouse for a church activity. But could you have a rule that you can't use the clubhouse for any commercial activity? Yeah. Can you have the clubhouse limit the groups? Sure, but we need to give fair use to everybody. So maybe there's a cap on how many people can come in. But if a group of your homeowner says, we all want to use the clubhouse on Saturday morning to meet, and they meet in the clubhouse on Saturday morning, and they happen to pray together, that's not your problem, because what they choose to do, so long as they don't damage your property, you don't care about. You can say it's not an open, and you can't put up signs, and you can't open it to the public. But you can limit numbers of how many people can be there, and maybe they want to do it every single Saturday, and you can say, look, that's not fair to every other owner who might want to use it on Saturdays. We'll take it one Saturday at a time, okay? What about ADA? This is why we don't want the pool open to the public. American with Disabilities Act does not apply to a community that is only open to its owners and their guests. So if your community is only open to your members and their guests, and those are limited in number by your rules probably, then ADA doesn't apply to you. And that's important, because there are a lot of things and a lot of costs that kick in if in fact ADA applies, right? So when we're talking about use of the clubhouse, if it's not open to the public, it's only open to members and their guests are limited in number, ADA is not going to kick in, and all the ADA requirements are not going to kick in. What about swim clubs? Swim clubs become a problem because you may exceed they may be from a whole group much larger than just your members. And so if that's the case, that could turn what is a private pool into a public pool. And if that's the case, then in fact, you're going to be have to bring your pool into ADA requirements. And once that happens, there are a lot of ADA requirements. You're going to have to make sure that you have a pool lift that is available during all hours that the pool is open. Now that requirement came in 2012, but back in 2012, we had lots and lots of articles about what makes a pool public. But again, now that pools are open again, it might be something to revisit and make sure your board's aware of how you use that pool. And if you make it only open to your members versus open to the public, can save you a whole bunch of information and a whole bunch of costs that you will have to bring the pool into compliance with if you make it open to the public. Pool rule checkup, make sure that you work through and have your pool ready. I mean, we haven't had to have pools for a while because of the pandemic, and now that we're back in place, we may need to dust off those rules. So go through your rules, make sure that there aren't any that discriminate against children. Make sure that the rules designate your open hours. Make sure your pools are distributed to all your owners and your residents. Look at your signs on your pools, right? Do you have cameras in the pool area? Okay. Do you have signs up that say that those cameras are not monitored? They're just used after the fact, so that you can't have an owner claiming, well, I relied upon your cameras to monitor my children and they were injured because you weren't monitoring them. Make sure your signs are adequate and going to protect your community from liability. Make sure your cameras are only operating in areas they're allowed to be. Obviously, they're not allowed to be in the locker room, okay? Make sure that you have gates that are operational and locks and fences that are operational. Remember that we want to make sure that if in fact, as I said a while ago, a pool's a hazardous area, right? So you need to protect so people can't randomly walk in and randomly use it without complying with our rules. If you have the ability to suspend privileges, if somebody hasn't paid, they don't get a key, they don't get the new lock code, then the lock has to be in operational order. The keys, the fences, the gates, all those have to be secure. Everything has to be in order. You need to know that that's ready for the summer and that they're ready to let them in. Remember, you cannot suspend somebody's use of the pool because they haven't paid unless it's in your declaration. Okay, owners have rights to common areas and access to those common areas. And unless your declaration gives you the authority to suspend their rights and their use of those areas, you can't just do so for the heck of it. So make sure that your documents give you that authority. And if they give you that authority, by all means, use it. It is one of the many provisions that will help an association get homeowners current faster than any other kind of provision in your toolbox. Remember that, again, safety reasons in your pool rules are great so long as they show a compelling need for safety, right? And that's the least restrictive way to get there. Okay, lifeguards or not. This is something that it is a analysis that your board's going to have to do. Certainly there is no absolutes, but if you don't have a lifeguard, make sure that you have signs up that make sure everybody knows that they are using the pool and they are using it at their own risk. If you are using lifeguards, you need to make sure that you have verified their training. Your contracts with those lifeguards or that lifeguard company needs to spell out what it is you expect them to do, okay? There's nothing worse than you're expecting them to monitor who's coming and going in the pool, and they think they're doing nothing other than actually watching the pool, and that's all they're focusing on. Big difference between watching who's coming in and out of the gate and that it's only one person bringing two people in versus one person bringing in 20. And I'm just watching the pool. You need to make sure that your contract with the pool company is very clear on what their rights are, what you're paying for, what their training is, right? That's something that you have to be clear in your contract to make sure that you're taking care of. The other thing you need to make sure is that you've got good contracts in place for the maintenance of that pool, right? Who's in fact taking care of that pool? Is that part of the same company? Is that part of the same contract? Many times those are separate contracts, and you want to make sure that your contracts are clear. I've had circumstances where communities have that pool contract and it's not clear. What happens if in fact you start seeing maybe something growing, some black algae, something in the pool? Is that the lifeguard duty to check? Is it the company that's coming to maintain the pool? Is there somebody who needs to kick everybody out? Oh my God, that's something bad. Is it not bad? Is it okay? Can we wait till tonight to flush the pool? Those things need to be thought out, discussed with your vendors beforehand. After the fact, it's too late. So you need to make sure that you know who's doing what and when. Are you going to have pool monitors? Are these people who are maybe committee members who are going to help you make sure that the use of the pool isn't overdone, that we're limiting the access? If you have pool monitors who are committee members, you probably ought to have a charter in place saying what their authority is to act, and they have good, clear directions on what they should be doing. Are they just limiting the access to owners? Owners can bring a guest. How many guests? Is that clear in the rules? Have those rules been adopted by the board? Are they posted? Can everybody see them, find them? Whose job is it at night to lock that pool, to make sure it's locked up before you go? Are there clear signs, no bottles in the pool area? What happens if one is brought in? Who has authority to demand they leave? Those are things you need to make sure that you have drafted up, written down, and in place when the pool opens. Cameras are great, and last summer, maybe summer before last, I guess it was, wow, time flies, right? It was before the pandemic, back when we had the pools open. We had a slew of kids who thought it was great to come into the pool area and pick up all the chairs and tables and throw them into the pool at night. Oh, that was a great game. Of course, it was damaging the chairs, damaging the tables, damaging the pool. And so many communities put up cameras to stop that nonsense so that we could find out who the kids were, who was doing it, what was happening, and get it stopped and taken care of. Again, if you have cameras, you want to make sure you put them in a good place. The other thing, obviously, make sure that you have something in place. You have somebody who shows up, he wants to prop open the gate to let all of his buddies come and go. Who's going to stop it? Are you going to kick him out, demand he leave immediately? Make sure you're ready to take the next steps, because it's not enough just to say no. You're going to have to be willing to shut down the pool, kick everybody out, and deal with those consequences. And that means you got to have somebody in charge to do it. So one of your committee members, most of your lifeguards are not going to feel comfortable telling an adult, get out. They might, but you got to be careful, and you got to know what you're willing to do. Do they have a phone handy that they can call somebody that you can come over and help? Have that system in place and ready to go. The other thing that you need to know is that, do you have signs up that say, when the pool is closed, that, it's closed after 10 p.m. No one's allowed in. Okay, so now you have somebody in there. It's after 10. What are you going to do about it? Well, if it's properly marked, no trespassing, nobody allowed after 10, police can be called. It's trespass. They can come deal with it. You can call the police in. It's not properly signed. Police might not be willing to take action, right? Establish processes for when do you have your companies come in for water checks. Stay on top of that. You don't want anybody getting sick and making allegations against you. While the pandemic is still not, as active as it has been in the past, it doesn't mean it's still not active. So if you had some hand sanitizer up before, out and about, are you still going to do it again this year? Probably wouldn't be a bad idea, but what's the process and who's in charge of it? Make sure that's all ready to go. Again, what happens when the rules are violated? Here's where we have the fun not so fun issues, because House Bill 1137 really has tied our hands to a big degree on what can be done and what can't be done, right? So if in fact you have a violation of your rules, you have to send a notice. That notice is going to have to follow your HB 1137 policies. Do you want to adopt different rules that say, if in fact you bring bottles to the pool and refuse to immediately throw them away or dispose of them, you will not be allowed back in the pool immediately, right? It's an action that is not a fine. Because remember, now with HB 1137, getting to a fine stage means there's a violation that has not stopped for 30 days. You are going to need to relook at all of your pool rules to find some more immediate responses. And that means getting your pool rules in front of the attorney, in front of the board, getting them changed and getting them in place before the pool opens at the end of the month. Because fining is now almost going to be impossible to accomplish, because the way HB 1137 says, you can't fine unless the conduct continues for 30 days, unless health and safety. Now, a lot of the pool things might be able to slide in under the health and safety, but that's still a 3-day to cure, right? So you're still going to have problems, because it still gives them 3 days to cure. And if they stop the activity, you're still never going to get to a fine stage. So you may need to rewrite your pool rules to work on utilizing immediate removal, because if you can't get to the fine stage, you're not going to be able to have some enforcement actions at your pool. Okay. What about playgrounds? Probably have, the same kind of conduct and same rules for playgrounds that you might have for pools. You might have areas that are tot lots. You might have areas that are for bigger kids. Obviously, you want to make sure that your board and your committees have done their inspection, looking for damage before the season starts. You want to make sure that, again, you're going to look to some immediate rule changes for you're not allowed in this area if you're doing these types of things, because we're not going to get to fine stage. You're going to have to modify your rules in these areas to try and keep control. This is a common area that you, the HOA, controls. You're going to have to modify your rules, because HB 1137 is not going to allow you to utilize fines to fix the problems anymore. Pets. Pets are another big one, guys. This is one that, come spring, everybody's out walking their dogs, playing with their dogs. Many of you may have problems with rules and such, right? And may have tried to stop renters from having dogs, because renters don't care about the parks, and they don't care if they pick up after their pet, because it's not their house, not their park. They're just renting there for a few months. And so many communities try and implement rules that say renters can't have dogs. You could really have some problems with this. This is not going to be a discrimination like a fair housing discrimination, because renters are not a protected class. However, you want to be really careful, because there has been case law that has come down that said rules for an association cannot create different classes of residents. And that's exactly what you're doing if you say renters can't have something but owners can. That case hasn't come to Colorado yet, but it could. So be aware of that. I have many communities that have rules that say renters are in a different position than owners. And I think that they should all be warned that that's a risk. It might fly just fine, and it may never get challenged. But if it's challenged, it could very well be a successful challenge due to the out-of-state case law. Obviously, we always have to remember that if you cannot prove who left the dog poop, you're not going to be able to pick it up. And with House Bill 1137, it says if the association determines that a violation, meaning we now know a name of whose dog pooped, the association is going to send that unit owner a notice. But if the unit owner cures it within 30 days, you can't proceed any further. So House Bill 1137 is going to pretty much tie your hands on dog poop. That means if you are in the city, I would be learning the animal control phone number and putting that on your webpage to try and stop the calls to you. Your hands are going to be so tied on dogs barking, dogs not being picked up after, dogs off leash. All of those issues regarding dogs is going to be almost impossible for an HOA to enforce with House Bill 1137. So you are going to have to dump all of that on animal control. So if you are in the city, get a copy of the city laws that apply to dogs, get a copy of the leash requirements, get a copy of the you must pick up after your dog, dog barking, get all of those things and make those available. So when those homeowners call you and yell at you, you can tell them the city statute. Here's the city code. Here's where it is. Here's the number to call to complain, because I can't do anything unless I can show it's a nonstop violation for 30 days. Be ready for that. You know, summer's coming and this is going to happen, and you need to be able to give yourself some sanity, and you're going to have to point everybody in a different direction. Same thing happens for parties, guys. When you're going to have those disturbing the peace, the loud parties in the park, the loud calls from the neighbor park, you know, the party. Cinco de Mayo is Friday, guys. Get ready. Here we go. When those parties hit, HB 1137 isn't going to help you. You need to know that what is the disturbing peace ordinance in that HOA's county, that HOA city. Know those disturbing the peace. Know and to tell when those people call you asking you to fix it, direct them to call the police. Again, you're going to have some problems trying to enforce. You're going to have a lot of screaming that you're failing to do your job, you're breaching your fiduciary duty. You need to make sure that you can tell everybody what you can and can't do, right? And you're going to have to pretty much tell everybody, guys, I get it, but look at my new policies. I got the new HB 1137 compliant policies. Look at this. This is what the law requires. I'm never going to be able to stop that party. So make sure that that homeowner who's complaining and yelling at you and threatening to sue the HOA because you're not enforcing the covenants, let them know you can't do anything more because of the statute, and give them their options, right? Is it going to stop the lawsuits against you? No, and that's why you have insurance. That's why you always want to make sure that your HOA is insured. And I know that's another complaint right now, and that's another day and another article. Again, this, you know, when you've got the parties, these are a one-time event. We're not going to be able to deal with them under 1137. If they are a party in your clubhouse, you may be able to stop it, because that one is a little bit simpler because you draft the contract, right? When somebody rents your clubhouse or they rent the pool area, you can draft up that no large parties. If you get too loud, you will be removed immediately, right? Put that in the contract. Now we're not enforcing covenants. We're not under 1137. We're enforcing a contract, the signed contract to rent the clubhouse, the signed contract to rent the pool, and get a larger deposit, right? To help you fight this stuff. Make sure they know if there's a party, they're not getting their deposit back. Make sure if they exceed the noise level, they're not getting their deposit back. Find other ways to control the situation so that 1137 doesn't stop us from enjoying our communities, right? You're going to have to think outside that box, find other ways to make things happen, right? What's the last big thing that we have to face now that summer's here? Construction, guys. Everybody's going to put in their applications to change their property. So let's make sure we're all on the same page about architectural review stuff. How do you remove somebody if they break a rule? Well, if they're in your clubhouse and they're loud, you make it part of the contract that they will be immediately removed and you call the police. If they're in your park and they're immediately, they're breaking the park rules that you've modified for immediate removal, and they're deemed trespassing if they're in groups larger than a set number, or they're exceeding the noise restrictions in your park, it's deemed trespass. You're going to call the cops on them. Obviously, you're going to tell the neighbors who are complaining about the neighbor's party to call the cops. So the removal is using the police. That's the only place we've got to go right now, folks, is we're going to have to get assistance from the city police, the animal control, to help us deal with, basically out of control owners or renters, because 1137 took it out of our hands. So let's look at our architectural challenges. Let's remember, guys, who's on the committee. I got lots of communities that, got a lot of shakeup in this. Let's get ready for summer. You've probably already got the applications coming in. Everybody's getting ready for long weekends. They're going to use the long weekends to do modifications. Email blasts to remind people this time of year. I understand you're all getting ready and geared up. You want to do all kinds of things that are beautiful to your home, and we really want to help you. Make sure you get those requests in early. Email blasts, newsletter blasts, reminding them to submit the plans, that it takes you a while to get it through your process to review. They have to wait to get the written review. They have to wait to get the approval before they act. Make sure that you're looking at things so that you're ready to do this. Make sure you know how many members are on your committee. Do they have to be owners? Can they also be board members? Can somebody hold both slots? Many times I have communities hire outside professionals without looking to their documents, and their documents may not give them legal authority to hire somebody and put somebody on a committee and pay them, and it's not in their declaration authority. If that's your case, you're going to have to work with your council and see if there's a way you can adopt a rule, or do you have to amend to allow this process. Make sure you know that you have given this process, that it's gone through the right person. Sometimes you have HOAs that have large committees, and they have large committees so that they can delegate. You take everybody on the south, you take everybody in the west, you take everybody in the north, you take everybody in the east, right? Everybody splits up, and if we have questions, then we'll get back together and vote. Do you have the ability to delegate? A lot of communities, it makes sense because you got a lot of stuff coming in and you're trying to limit the work, right? But you may not have that authority to delegate. The documents may require that all of the members vote on everything. And if that's the case, you need to make sure that you can do so. Can you charge a fee? And do you have the ability to put it on the ledger? That's something that you have to look at and make sure that you have document authority to do. There are a lot of things in the documents that might give you that authority. But if you're a pre-Kiowa community, it has to be in your documents, because there's no authority to charge different amounts in Kiowa if you're a pre-Kiowa community. Now, if you're post-Kiowa, there's abilities to charge different amounts to different owners if it applies only to a different owner. But you may not have that right in pre-Kiowa community. So you may not have that ability to just push that fee of that engineer off on a homeowner. So make sure you've looked at your documents and your documents are clear what you can or cannot do. What's your criteria for review? This is something that gets challenged more and more. You need to remember that guidelines help your committees. They help them in a lot of regards, but the main one is to be consistent. If you have a community and your declaration says everything has to be pre-approved, that gives you really good grounds to have clear guidelines. Make sure your guidelines are set up so that you can tell what you're going to allow. I mean, it helps not only to put your owners, right, on clear notice. I'm not going to allow any metal sheds. I'm not going to allow any chain link fence, whatever you choose for your community, whatever matches your community, right? Make sure that that information is in your guidelines. Homeowners now know it's not this guessing game. I wonder what they're going to approve, what they're not going to approve. They know it's in writing, and it helps your committee be consistent with every single homeowner. And then if you get challenged because you denied a chain link fence, but your guidelines say no chain link fence, it gives support in court, right? This isn't an arbitrary or capricious decision by the committee. Please read the guidelines. The guidelines say no, it's not allowed. So it was a really simple thing. And again, it's something that helps you if you end up in court. Now, the point of guidelines are not to repeat the declaration, right? It doesn't help you to go into the declaration and take the provision out of the declaration and repeat it in the rules. That's not helpful. What is helpful is if your declaration says, we expect things to match. Well, what does that mean? It means that if you're going to allow sheds that you're going to have sheds that have the same roof material as the house. It's going to have the same siding as the house. It's going to be painted the same color as the house. The trim will match or be the same color as the trim on the house, right? Explain very clearly what you, the board and the committee, mean by match, by spelling it out in your guidelines. So it's clear that you're setting forth what you're going to allow, what you're not going to allow. Remember that, one of the things you have to look at is who has authority to draft those guidelines, okay? I've had a lot of communities that presume that the board gets to do that, and guess what? The documents say very clearly it's the ARC, the Architectural Review Committee, the Architectural Control Committee. That's who gets to draft the guidelines. The board has no vote in it. Look who has the vote. Look to your declaration and see who has the vote. It could be different. And if you were managing a portfolio of 12 communities, you might have 12 different versions. Who knows? Look to your documents to get the specifics, okay? Committees and owners all come in with these assumptions. I had many communities assume everybody understood you can't do this. And when it's verbalized, both sides look at each other and go, I didn't know that. Okay, don't have those assumptions, okay? Make sure that it's spelled out. Make sure that if you don't want metal sheds, it says no metal sheds. If you don't want Rubbermaid sheds after 5 years because they start sagging and they start discoloring, state if you put up a Rubbermaid shed, you're allowed to have it until it becomes discolored. Once it starts discoloring or losing its shape, it must be removed. I mean, if those are your presumptions, put them in there. Don't assume that all homeowners want to maintain their property. It just doesn't exist anymore. People don't have time, and with our economy, a lot of them don't have money, and so they're looking for quick outs. So don't assume that everybody will do it. I went to court many, many years ago because homeowner came and talked to the committee and had all kinds of discussions, and the homeowner promised to supplement his plans, and the committee approved it based upon those verbal promises, and they were never kept. So committee basically gave that homeowner a blank check, said yes, never got supplements, never got anything, and what the homeowner built was not what the committee wanted, not what they allowed anybody else to do, and yet they had nothing in writing but a blank signed form that said, yes, you can do this because, somebody had made a verbal promise. Verbal promises won't help you. If you want something specific, require it in writing. What you see listed on a form, presume that you are devil's advocate. Look at the form and presume, could you be allowed to do the ugliest thing you can think of, and see if that still fits under the description given to you. And if it does, you have a problem. Be specific enough to get what you want and to keep it in compliance. Understand that most homeowners most homeowners want to comply with the HOA so long as they get what they get. They get what they want, okay? You need to understand that forgiveness is always easier than permission. And if you let homeowners play that game, they will. So you set the guidelines by holding their feet to the fire. Here's the rules. You can't build until you get a written signed approval, and don't sign an approval that doesn't tell you exactly what they're going to do. Remember the deadlines, guys. Those deadlines will bite you. If the document says if the HOA has 30 days to complete something, and in fact the committee looks at it, then at the end of 30 days you better have issued a response. Many of them say that failure to answer within the 30 days may be deemed an approval. Make sure that in fact you have met your deadlines and that you have worked through what needs to happen on time. If your deadlines say, or if your documents say, if the application is incomplete, the timeline doesn't start until it's complete, that's great. Make sure there's something in writing showing you sent the owner a letter, an email, something that said, your application is incomplete. We still need X, Y, and Z. Don't rely on a verbal discussion of, we still need this information. Make sure it's in writing, you're still waiting. Most documents don't say an incomplete document doesn't start the clock. So make sure that you're meeting the deadline and saying, hey, we're still needing these things. We have to deem this denied right now until we get these things, then we'll reopen it and review it again. But for now, it's denied. Send out letters being very clear that it's denied because it's incomplete. You're waiting to start the clock because it's incomplete. Some old decks say if you don't file a lawsuit in court before the project is completed, it's deemed approved. If your documents say that, amend immediately. If you can't amend, you better have your attorney on speed dial, because a roof takes 1 to 2 days. A shed can be installed in 1 to 2 days, and you're going to have to file a lawsuit very quickly. And you're going to have to worry about how you're going to do that and comply with HB 1137. And there may not be a way to do both. So I highly recommend you amend if your document says that. Again, look at your documents about whether or not there is a deadline to appeal. There's nothing in the statute that says anybody gets to appeal. But if your documents say there's an appeal right, know who the appeal right is. Is it the owner? Is it the neighbors? Is it both? Who has that right? Does it go to the same group? Does it go to the ARC? Does it go to the board? Make sure that you know the day it went in. If you get a complaint, make sure you have them write down the day it was built. Statute of limitations, 1 year from the date it was built. Make sure that's in the documents, because 2 months down the road, 3 months down the road, you've sent both of your HB 1137 letters and you're turning over the lawyer, or the board's wishy-washy and they're going back and forth, and it goes to 4 months and 6 months, and all of a sudden you're looking, oh my God, when was that thing built? Are we at the end of our statute of limitations? Make sure there's some notations and that you're tracking that. What else you need to worry about? Conditions, right? If you're going to say, yes, you can build this on the condition you do X, Y, and Z, make it very, very clear, right? Approval is based upon condition that these things are met. Again, your letters need to be clear. Your documents need to be clear. One of the things that often happens is application is submitted, it's accepted, it's saved. The board makes notes on it, or the ARC makes notes on it, then they send it back with their conditions. Make sure you have the original copy somewhere without all the handwriting on it, because if this goes to court, you're going to need the original copy as well as the one with the board notes. Make sure that, again, the right party is approving it. Many times the only approval rights are with the ARC, the Architectural Review Committee, or the Architectural Control Committee. It's not with the board. And many times if the ARC gets concerned and there's fighting going on and they don't want to be involved in the fight and they want the board to make the decision, that might not be something that they have the authority to delegate. They're the ARC. If your deck says they have to make the decision, then they have to make the decision. They don't get to delegate to the board because they don't want to be in the middle of the fight. Make sure you know that they can or cannot delegate before that happens, because otherwise your approval or your denial is going to fail because the wrong person made the decision. Make sure that if in fact you have resubmittals, that the committee doesn't ignore them because there was no change. I cannot tell you the number of times that I have had a homeowner get denied, submit it again, and the committee says, it's the same as last time. No, I'm not doing anything with it. I already told him no on that. And he takes that case to court and says they had to agree or deny my decision 30 days. Here's my second submittal. They never did anything on it. I'm now approved. I win. Okay. Resubmittals. Stamp them denied if they're the exact same. It's the same thing as before. Stamp it denied and send it back. Doesn't matter how many times they do it. You can't just refuse it, because if your documents say 30 days or it's deemed approved, you better be stamping it denied and mailing it back out. Make sure you go through all those facts. What about variances? There is no legal right to a variance. There is nothing in the law that gives people the right to a variance. Understand, What you're saying with a variance is my declaration prohibits all chain link fences, but I'm going to ignore my declaration and give you a variance because I'm the board. Well, if that were legally allowed, we'd never have to amend anything. The board would just allow what they want, right? There is no legal right to a variance outside of what your governing documents talk about. And what your governing documents generally say is if due to specific reasons that won't be to the detriment of the rest of the community, you may be allowed to grant a variance. Well, what does that mean? The simplest kind of example I can give you is many communities have requirements of a set number of trees in the front yard. What if you have lots that are pie-shaped and you can't fit the exact number of trees in the front yard? It's appropriate in that case to give a variance to that homeowner in the pie-shaped yard to put their trees in the backyard. Why? Because it's still fair to the community. Every homeowner had to put in the same number of trees. This homeowner, because of the topography of his lot, nothing he did, nothing anybody else did, he gets to put his trees in the backyard rather than the front yard. Okay, so give them sparingly, give them consistently, in that if you do something and you're allowing a homeowner to do something, it's fair in comparison to what his neighbor had to do, right? Shifting trees front to back to fit the topography is fair. It's consistent. Both homeowners had to put in the same number of trees, right? You want to make sure that you know that if you do this, you have to do it for everyone in like circumstances. So when you get that really sweet grandma who can't afford to do something, and she goes, can't you just give me a variance? And you think she is so nice and everybody loves her. Well, everybody else who's just a little nice little old lady in the exact same circumstances, and even if they're a mean little old lady in the exact same circumstances, all have to get the same thing. You can't treat people differently just because one's nice and one's not. So be aware that you have to be consistent. Is there a right to appeal the committee? No, only if your documents say so. And who is it appealed to depends on what your documents say. Some documents appoint the DRC as the final decision maker, and if they deny it, then your only option to challenge is to go to court. Some say you can appeal it to the board for a final decision. Great. What if the DRC and the board are one in the same group? Well, they're going to make the decision twice because you're going to have to follow the process. And the process says they can appeal and put on your different hat as a board member. What if only part of the DRC is on the board? Should they vote? Probably not, because it defeats the purpose of allowing for an appeal. You want to work with your attorney to work through all the different parameters of each of those and make sure that, again, you're doing so. If you have an appeal, let the homeowner come in and explain to you why they believe it should have been approved, why they believe that your actions are different from what you've done with everyone else. Don't presume. Know that you're going to have to make a decision just like you would in a hearing, but let them have the floor. Let them present to you. Don't get in a fight with them. Don't argue with them. It's fine to ask clarifying questions, but don't argue. It doesn't help anybody. Once it's built, with or without application, make sure that what they built matched what you approved. If it didn't, go through your violation process. Make sure that if you have fine processes that you go through your HB 1137 compliant policies, send the notices. Remember that 1 year statute started the date they built it, not in compliance. So if you told them that you had to build it in the far corner of the lot and they start building it right next to the front sidewalk, the minute they start building is the day that clock starts ticking. Not when they finish it, but when they start, because it's in the wrong spot. But if they build it in the right spot and they start building and it looks like they're building what you approved, when you can see that they're building different than you approved is when your clock starts. That requires you pay attention. It requires the neighbors pay attention. And if you're going to go after them, that you have photos and you can show how it's different than what you approved. Again, if you're going to send those violation letters, be clear. What was it they did? They sent said, I'm going to build a 4x4 play area for my kids. The minute they dug it out and it's 8x8, you know that's a violation. Okay, you were approved by 4x4, you're building 8x8. Resubmit or stop building. You know, send your notices, be clear what they're violating, be clear why it's a violation. Can they have an 8x8? Is it they just need to resubmit? Make sure that's clear. If they can never have the 8x8 because you don't allow anything that large, then let them know that it's never going to be approved. What happens when it gets to court? Well, the court looks at 3 cases in Colorado. These 3 cases are going to give deference to your decisions as the ARC, so long as the decision is not arbitrary and capricious. These cases all say that it is not for the court to look at your facts. It's not at the court to say, I like this color over that color. The court's job is only to decide, did the ARC look at this fairly, and did they look at it consistently and in good faith? And that goes back to what we started this class on, which is having guidelines or having rules that show you, here's how we're going to rule. And so if your guidelines say, I'm only going to allow this, and that's exactly what the ARC did, then they clearly weren't arbitrary or capricious. They just followed their own guidelines. So make sure that you have clear guidelines for your committee to follow, because that will get them down the path, and then the court will have no choice but to give deference to their decision, because there's no action that's arbitrary. They just followed their guidelines. And I think that's all I have, unless I have some questions. I've never had this. I don't have any questions. Either you're all typing furiously or you're all bored to death. Well, thank you all very much. It looks like I don't have any questions. Thank you all for listening. And everybody, I hope you have a great summer. I hope you all have a great party tomorrow. And you all enjoy Cinco de Mayo. Have a margarita on me. You guys all take care. Have a good summer.